Welcome to the All Rise podcast, Sunday Scaries. I'm your host, Christine, a civil litigator and personal mentor. Every Sunday, we'll tackle those dreaded Sunday Scaries together to demystify the practice of law and provide you with actionable tips and guidance to face your week ahead. So grab a cup of coffee, take a deep breath, and join me while we turn those Sunday Scaries into stepping stones towards your success. Let's get started. Welcome back to another episode of All Rise Mentors Sunday Scaries, where we tackle those Sunday Scaries head on and turn anxiety into actionable insight. I'm your host, Christine Barker, and we are diving into a topic today that is crucial for all attorneys, but especially new associates, and that is how to lose and still win. Now, losing a case or knowing that you are up against insurmountable facts that it's likely you're going to lose is really disheartening. It's disheartening for new attorneys. It's disheartening for seasoned practicing attorneys. It just sucks. Nobody likes to lose. But believe it or not, there are some gains that you can get from these experiences and kind of learn from them. And knowing that all cases are not winnable. Sometimes you just have bad facts. Sometimes you just have a client or a witness that is just not going to present well to trial, and that's not your fault. One thing I had to make sure that I constantly reminded myself as a new attorney was I did not create these problems. I wasn't there when my client didn't get a signed change order for extra work. I wasn't there when, someone was distracted while driving a car and caused an auto accident. I wasn't there when, someone made a poor decision, while working and, employer had to fire them. Like, you're not there for when those actions are occurring. They're not your fault. It's not your fault that you have a bad case or you have bad facts. What you need to do, though, is you need to be able to recognize those bad facts, those challenges to your case, and know what to do with them. So let's unpack all of this together. First, like I said, let's acknowledge the elephant in the room. Losing sucks. Nobody likes to lose. You don't like to lose. I don't like to lose. We all went to law school for some reason, and likely part of that reason was we like to win. We like to win arguments. We like to win cases. We like to be right. There's nothing wrong with that. It's okay. Just embrace the fact you like to be right. So do I. But in the legal world, it is inevitably part of the job. Sometimes you're going to lose, and that's okay. The key is to shift the perspective from seeing a loss as a failure and viewing it as a learning opportunity. So kind of some key points to understand, and that is, number one, losing is part of the profession. We're all going to lose at some point. It's okay. Just deal with it. Even seasoned attorneys lose, and that's just part of the job. It's a normal part of growth. It's a normal part of your development. It's a normal part of the career. So let's just normalize the fact that losing sucks, but losing's a reality and it's just going to happen. But like I said, there are things that you can learn from losing. When you lose a case or you lose a motion or you anticipate a loss, you take a look, you sat down, you interviewed your client, you're looking at the documents and you're like, this case sucks. We're not going to be able to win. It's crucial for you to conduct a thorough evaluation of the case. And if in fact you have gone through the loss, you lost the motion, you lost the case, it's really important, and I know it's uncomfortable. You got to do a post-mortem analysis. You got to look at the loss and you got to figure out why, especially if it came out of left field. If you thought you were going to win the case and you didn't, then it's really crucial that you sit down and figure out why. What changed? What quote went wrong? So that you can learn from that and you can adjust and you can move on. Don't beat yourself up over this. I know that that's hard. I still do it. I have to remind myself, these are not my problems. I did not create this. Any given Sunday, someone's going to be able to come out and present the evidence differently. If it's a jury trial, you've got a jury there. They all come with their own biases. So just don't beat yourself up over a loss. It's about understanding what happened and then how you can improve. And sometimes that improvement isn't you doing anything differently with the case. It's you realizing the venue that you're in. Is this a venue that is more plaintiff friendly, more defense friendly? What kind of demographics do you have? Do you need to do more research on the judge? In California, we've got a provision in the civil code where we can challenge a judge if we don't feel that they could be impartial to our cases. Judges are human too, and sometimes their biases come into play. So it's really important that if the reason that you think that you lost is not necessarily because you had bad facts or a bad witness, but you think maybe it was the venue, be objective. Don't blame everything on the judge. Don't blame everything on the jury. Be very objective about why the outcome happened and then what you can do to prevent that or change it or anticipate it on the next case, the next go around. When you're doing this post-mortem analysis, couple of key things that you need to keep in mind. That is, number one, review the case in detail. What were your strong points and what were your weak points? Was there a way that you could have presented this evidence in a better way? Was there a better witness that you could have put on the stand? Is there a better argument that you could have made? I know I'm talking a little bit more about trials, and that's probably because I have one coming up, so that's where my mind is right now. But as a new associate, it's probably not going to be a trial. It's probably going to be law in motion. It's probably going to be a meet and confer with opposing counsel. It's probably going to be maybe a mediation. And these are not, devastating results. It's not going to be kind of the end all be all for your case if you lose a demur or if you lose a motion to compel. But it's equally important that as an associate that you take a look at those losses as well. And that way you can make kind of mid-season adjustments. Clearly football season's coming up with all these football analysis, or clearly football season is coming up with all of these football analogies. Next, how did the opposing counsel outmaneuver you if they did? One of my favorite things to do is to learn from my opposing counsel. There was a case that I had probably about, I want to say, 8 years ago. And it was a really big case. It was a construction matter, and my client did micro tunneling, and they were supposed to be putting in this new trunk line for a sanitation department. And during the tunneling, they had to go underneath a dried river. And while they were underneath this river, because it was a micro tunneling, so they actually did it by like remote control. It was kind of cool. So there was nobody actually manning the tunneling machine. There was a guy standing on the shore banks, and he was doing it with basically like a Nintendo remote control, but I digress. So anyways, during the tunneling, they hit some differing site conditions. They hit some quote unquote quicksand essentially, and they started to lose the machine. It was sinking, and they had a problem trying to get it to come back up. Otherwise, it was just going to sink into underneath this riverbed. And so my job was to defend the microtunneler. My client was the one who was actually doing the tunneling, and we were in a lawsuit with all of the design professionals, geotechnical people who were supposed to predict what the soil's conditions were going to be like. And I'm in deposition, where I'm taking the deposition of one of the design professionals, and opposing counsel is this incredibly sharp attorney who's from San Francisco, and I just remember being so intimidated by him because he was very sharp, he was very on it, very articulate. And I must have taken I can't even tell you, I must have taken a break every 30 minutes because I needed to go collect my thoughts and calm down and not get intimidated. But I will tell you, one of the things that I learned from that case was I rose to the occasion of this attorney. And there were times during that deposition that he did outmaneuver me. And I could have taken that as, oh my God, in reinforcing my imposter syndrome. Oh my God, I suck. He's better. I shouldn't be here. He should be doing all of the litigation in the entire state of California. I mean, I could have gone down that spiral. Instead, afterwards, I really did sit down and do a post-mortem analysis and was like, okay, how did he outmaneuver me? How can I prevent this in the future? Because this was just one deposition, and I felt like I lost the quote deposition. But I didn't lose the case. And how could I take what happened during that deposition and turn that into something that was going to be beneficial to my client, that was going to help me advance my client's position and eventually help me win that case? The case did wind up settling, and which was, a good result for everyone. So the loss didn't turn into a loss for the case. It was just one of those minor setbacks, but it did give me an opportunity to evaluate how I was doing, to evaluate how I was outmaneuvered, to learn from that, and really to advance beyond that. So really important things to really sit down and do that analysis so that you can move forward. Seek feedback. So after you've reviewed your case in detail, seek feedback. Feedback from your partner, feedback from a colleague, feedback from, potentially from opposing counsel. I actually did reach out to this attorney after the case was over. And we were able to really have a nice conversation about the case, about, strategies, things like that. We talk a little bit about, seeking out mentors. He didn't know he was mentoring me, but I sought him out and had a really nice, probably about an hour-long conversation. And I gleaned a lot of information from him during that conversation. So do seek out feedback. Another thing that I did in that case was I got a copy of the deposition transcript and I gave it to my partner. And I asked my partner to review it and give me feedback on my questioning. How I could have, what did I leave on the table? Things that I could have followed up on. That's really important. I did it myself, but it's nice to have a second set of eyes. And if it's not, if your partner's too busy, seek out somebody in your office to read that deposition transcript and give you feedback as well. Be open, though, to constructive criticism. If you ask for it, you're going to get it. And you should ask for it. So just make sure that you've thickened up a little bit, you've got that thick skin going, and you're going to be able to receive that feedback and then put it into play so that you can then advance and move on. Document your lessons. I do keep a lot of my old notes and reviews. I keep all of my old reviews. I've got a file of them and I like to review them sometimes. Number one, to see how far I've come and see if I slip back into any of my old habits. And I can recognize that and be able to move on. So do keep a journal, keep a digital record, all the insights that you get from these different cases. It's only going to make you a better lawyer. You're building the building blocks and the foundations right now as a new associate. And it's only going to help you build and get better. So keep that constructive criticism, and be mindful that it is constructive. Document all of your lessons and review them whenever you get an opportunity. Number 3, strengthen your resilience. Losing does build resilience, and that's a trait that is indispensable for any successful attorney. The more challenges you face and the more setbacks that you have to endure, the more you develop the mental toughness that you need to handle future cases. So my caseload right now, as a 5th or 6th year attorney, I wouldn't have been able to handle it because I wasn't there mentally yet. I didn't have that mental toughness. I still thought every loss was a reflection on me. And I know that that's not true. Some portions of the loss are reflections on what I did or didn't do, but not all losses reflect the type of attorney I am or the potential that I can. It's okay to lose, and losing does help you build up that resilience. So kind of things to keep in mind is, number 1, embrace the discomfort. It sucks to lose. It does. I can't say it enough times. It does. But you need to acknowledge your feelings, that it sucks, that it kind of hurts your feelings, but don't let it overwhelm you. When you get constructive criticism back and it's harsh, okay, that stung, but don't let it overwhelm you. Don't let it prevent you from moving on. Get you into that analysis, paralysis by analysis, where all you do is just keep thinking of all of the ways that you've screwed up, and it doesn't allow you to move forward. Focus on the bigger picture as well. One loss does not define your career. Doesn't define you, doesn't define your career, doesn't define you as an attorney, does not define what your potential could be. It does not define you. Use each of these experiences experiences to help fortify your legal career. That look at these and you know what? This is just building me up. This is just teaching me more. It's a practice of law for a reason. Number 4, strategic thinking when the odds are against you. So sometimes you know from the start that the law isn't on your side. You take a look at it and you're like, nope, this is going to be a bad case. I can see by reviewing the facts with the law that the likelihood is we're going to lose. And I know that, you learn this in law school, but I still teach this to my associates and I still use it myself. IRAC, issue, rule, analysis, conclusion. It is important. I do this with my law in motion. I do this with my reports to clients. I do this with my outlines to myself because it is important for you to outline. What is the issue? What is the rule? And what is your analysis? And what's the likely conclusion? And when you do that for your cases up front and early on, you may be able to realize, look, this is a loser of a case, and that's okay. In these situations, the goal is to advocate as efficiently and effectively as possible and then prepare for the best possible outcomes under those circumstances. That might mean that you need to have a tough conversation with your client that says, hey, look, the likelihood that we're going to succeed at trial is less than 20%. I mean, you've got clear liability here. If you're on the plaintiff side, sitting down with your client and say, I know you feel wronged, and I know that you feel like someone else should bear the responsibility for that, but these are the facts and it just doesn't fit with the law. I remember a partner that I used to work for, and he would want me to, he would want me to, square peg, round hole. The client wants this, I need you to deliver it. And I used to say to myself so many times in my head, never in writing and never to him, but in my head I would think, I know you want the law to say that, it just doesn't. And my job as the associate was to explain to them why and just give them the potential outcomes. Now, at the end of the day, you're a representative of your client. It's your client who gets to make the decision, but it is your job to tell them what the likely outcome it potentially could be. And then they get to decide under those circumstances what they want to do. Couple of key points here, and that is number 1, develop a clear strategy. Identify your client's most compelling arguments. And there's going to be some. I mean, they might still be losers, but you've got to identify the best ones. And look for any legal nuances or precedent that might be able to support your case. It's going to have to pass the smell test. You can't get up there and a law in motion and argue something that is just, never going to happen under law. So you need to look and see what is the best argument that I have, and then look for some legal precedent. Try and compare prior cases to the facts of your cases and find those similarities. Also, like I said, manage your client's expectations. Be honest about the challenges and the likely outcomes. It's their decision, but it's your job to let them know what the potential outcomes could be, and you need to be honest. I do see a lot of young associates who, again, don't like to lose and they don't like to give their client bad news. But you're not doing your client any favors by pumping them up on facts that are never going to be able to be proven, evidence that doesn't actually exist or that you're not going to be able to present at trial, and outcomes that are contrary to the law. So it is really important to prepare them for the likely outcomes and for the challenges. Prepare them both for the best case and the worst case. And then I like to give them kind of a percentage, the likelihood that one or the other is going to be the outcome. Focus on the process and not just the outcome. What I mean like that is be well prepared, and what I mean by that is a well-prepared, well-argued case, even if it's going to end up in a loss, still enhances your reputation and your experience. In another way, it is if you present all of the facts, the challenges, and the likely outcomes to your client, and they say, you know what, I want to go forward still. Don't mail it in because you think you're going to lose. Don't mail it in because the law is against you, the facts are against you. Go back and find your most compelling arguments. Look for any of those legal nuances and precedents that might support those arguments, and then prepare. Do the best that you can with what you have. Even if you lose, you are still gaining the experience and the reputation. So just keep in mind that it's not always about the outcome. Some clients will say it's the principle of the matter. That's why I want to continue. I tend to try and talk them out of this because I have met very, very few clients that it actually is the principle of the matter. More likely it is the economic outcome that they're after, and their emotions have gotten in the way, and they think it's the principle. Again, this is something that managing expectations of your client. Something that if you do get a client who is like that, who is pushing back on you saying, no, it's the principle, make sure that you sit down with your partner and you guys can devise a plan in order to communicate and manage expectations to your client, so that you then can move on and actually prepare for a case. Finally, finding the wins in the losses. And every case, win or lose, often has very valuable takeaways. So, professional growth. Each case helps you hone your skills and develop your legal knowledge. You're learning about a new area of law or a new nuanced area of practice every time you lose. So, be open-minded and understand that those losses are helping you hone your skills and expand your legal knowledge. It builds credibility as well. Demonstrating professionalism and dedication, even in difficult cases, earns the respect of colleagues and clients and your partner. So continue to work, even if you know this is a loser of a case and you guys have sat down and you know that it is that the facts are just against you, the law is just against you, but your client wants to proceed with emotion, wants to proceed with, withholding documents pursuant to a privilege or an objection. Continue to maintain that professionalism and that decorum, even if you're taking an unpopular position and you know that you're potentially going to lose. It does earn the respect of your colleagues, your client, and of course, your boss. And then it also helps to build client relationships. Handling a tough case for a client with integrity can strengthen your relationship with your client. I've had a number of cases this way where I've had to explain to clients that, look, this looks like a loser of a case. And I have one in particular where he's like, I know it is, Christine, but I still want to go. And we actually were, on trial's doorstep and were able to settle the case. And it was because I had fostered that relationship with my client. I continued to remain professional and dedicated to the client. I had worked out the best possible outcome that I could have. I was well prepared. Sometimes just being well prepared is the thing that's gonna help you, and it's gonna take you over that finish line. All of us as attorneys are super busy, and it's really important. If you stay well prepared, sometimes you can outmaneuver your opposing counsel that way. But we can talk about that in another segment. So to all of my new associates out there, remember, losing a case isn't the end of the world. In fact, it's a stepping stone to the path of becoming a really great attorney. Embrace each challenge, learn from your experiences, and keep moving forward. Thank you for tuning in to this episode of All Rise Mentor Sunday Scaries. If you found this discussion helpful, please do subscribe. There's a QR link in the notes below. Leave us a review, share this podcast with your colleagues, and until next time, face your Sunday Scaries with confidence and turn them into opportunities for growth. Thanks so much.